The Attorney General made that statement, among others, via a recent airing of his Facebook show, Issues in the News. The Attorney General likened the amendments made to the Fiscal Management and Accountability Act, FMAA, by the APNU AFC in 2015 to the then government chopping its own budget.
It comes to the floor of the Parliament where for the first time the Finance Minister is seeing that the DPP is asking for $5 billion. He then realizes that he can't afford $5 billion. So what he does, he stands up, never seen before, and chops the DPP budget in half. A government chopping its own budget, so to speak.
Nandlall explained that essentially what transpired since the 2015 amendments were made to the Act was that constitutional agencies such as the court and other service commissions were allowed to submit their annual budgets to the Clerk of the National Assembly to be tabled in Parliament, instead of going through the Minister with responsibility for finance, who forms part of the executive arm of government. It is the executive arm of government, the Minister posited, that is responsible for matters relating to revenue and expenditure of the state.
But this collection of bright boys and girls thought that they were going to do that. And according to them, they were enhancing transparency and enhancing accountability. I have never seen such madness in my life.
Nandlall proceeded to read a ruling handed down by the learned Justice Harnanan in keeping with the doctrine of separation of powers.
The clear and unambiguous language of 218(1) of the Constitution establishes that the preparation and presentation of the financial estimates of revenue and expenditure of Guyana, the national budget, is an executive responsibility under the doctrine of separation of powers and the current statutory framework.
Speaking with Nightly News on Monday, the Shadow Minister of Legal Affairs, Roysdale Forde, posited that Justice Harnanan ruled that the 2021 amendments to the FMAA were unconstitutional and that coercive orders were made to have them reversed. Nandlall acknowledged that Justice Harnanan did make a ruling, pronouncing that the PPPC administration did err when it attached the constitutional agencies listed in the third schedule as budget agencies, instead of what they actually are, constitutional agencies, for which budgetary allocation is to be charged directly to the consolidated fund.
The court ruled that one component of those amendments, another section, that attach these agencies as what you call budgetary agencies in a schedule to the Fiscal Management and Accountability Act, that to treat them as budgetary agencies, that would be wrong because they are their expenses is a direct charge on the consolidated fund.
In March 2021, shortly after the laying and passage of the 2021 estimates in the National Assembly, Ganesh Mahipal, the applicant, through his attorneys at law, namely Roysdale Forde, Senior Counsel, approached the court, asking it to find that the 2021 amendments to the FMAA by the incumbent administration was in violation of the Constitution, according to Article 220G. The APNU AFC's contentions were that the government of the day was seeking to bring those agencies listed in the third schedule under the control and direction of the executive and sought to have the amendments cast aside, while asking it to revert to the 2015 amendments made by the coalition government. Members of the media were barred from observing the ruling. Wendell Badrie for the HGP Nightly News.